Good morning, everyone. How's everyone doing today? Did you enjoy your brief summer yesterday? Now we're back in winter. Well, my name is Judy Boniface. I'm the Chief Marketing Officer at Mailjet. On behalf of Braze and Particle and Mailjet, welcome to GDPR Beyond Borders. The General Data Protection Regulation comes into effect in less than 100 days. So today's focus is really going to be on how global brands like yourselves with European operations and ambition can start preparing for the necessary changes. It is really estimated that the cost of non-compliance can be as high as 2.7 times the investment needed to be compliant. How many of you have started preparing for GDPR? Show of hands. Great, bravo. Speaking from experiences from Mailjet, the compliance journey can take as long as over a year, as short as a couple of months. So it's good that you guys have already started. For those who haven't, though, don't worry. Just think of today as your jumpstart to join the compliance train. We have brought together experts from both sides of Atlantic today to help you understand just what GDPR is, what your risk exposures might be, some concrete actions you can start putting in place, as well as how you can work with third-party solution providers or your technology providers. After these panels, we'll take a short break before you have a choice between two different tracks on details, to deep dive into details on change implementations. One of the tracks will focus from a marketing perspective. The other track will help you understand what change means from an IT point of view. The GDPR is really a massive step towards user privacy and data protection. However, it has tremendous impact on brands like ours and our relationships with our customers. To thrive while being compliant, your teams within your organization will need to work together in lockstep to create a customer experiences that continuously add value and prove the brand's worth, while your technology providers needs to ensure that your data protection is within compliance. It's a complex set of laws, so we really welcome your contribution to our discussions today during the panel as well as during the workshops. If you have already started on the compliance journey, we really welcome you to share your experiences with everyone today so we can learn from each other. Okay, without further ado, let me introduce our keynote speaker for today, Dr. Pierre Nicolas Schwab. Dr. Schwab is the chairman of the Big Data Initiative at the European Broadcasting Union. He also leads the Big Data initiatives at the RTBF, which is a French-speaking public broadcaster in Belgium. With proximity to European Union, he has worked closely with the Article 29 working parties at the European Union, and he has led the GDPR compliance effort for RTBF. So let's welcome him on stage.
Thank you so much for being there today. I'm very happy to have the opportunity to talk about GDPR today. Yesterday I did a little bit of tourism in New York. I was there anyway, so I went to a drugstore that everyone knows. It's Duane Reade. Is that correct pronunciation? And those guys are going to have a big problem. Because when I wanted to pay, they first asked me for my phone number. Yeah, And when I asked the person at the desk why they were asking my phone number before even being able to pay, she was not able to answer that question. So that's not normal. That's something that will not be allowed anymore under GDPR because I'm a European citizen. I took a coffee in Soho yesterday. The same happened. I had to pay with my card, and because they were paper-free, I had to enter my email address to receive the American Express receipt. And soon after I did that, I received an email informing me about best deals and so forth and so on. But I did not opt in. This is something which is illegal because I'm a European citizen. So those things are also important for US companies, and that's what I would like to highlight today. So what is the general data protection regulation? First of all, it's a booklet of 88 pages, written small. There are a few lawyers here in the room. They will be very happy to decipher it. And the problem is that all those lawyers will not necessarily tell you what the practical, technical implications may be if you want to implement GDPR. We went through that at JBF, and we went also through that at the European Broadcasting Union, so I'm able to explain you what are the implications in terms of architecture, what are the different steps that you want to take. So I would like to explain today what the objectives are, very clearly, very simply. I'm not a legal person, I'm just an IT guy with a legal background, and I have implemented GDPR in my company, so I'm able to answer all the questions around that. Okay, so what is the spirit of the law? First of all, it's to give control back to the user. And because, why do we want to do that in Europe? Because many companies, especially US companies, I'm thinking about Facebook, I'm thinking about Google, have not adopted a real code of ethics and have adopted some cowboy behaviors in collecting and treating the data of their customers. And the Commission, the European Commission, at a certain point said that has to stop, and that's how GDPR came into action. What are the consequences for US companies? Very simple. First of all, if you handle data from US citizens, you have to comply with GDPR. So don't think that you are exempted of being GDPR compliant because you are based in the US. That's not true. So from the moment you have data of US citizens, of European citizens in your data bank, in your database, you have to be GDPR compliant. And it goes way beyond the Privacy Shield. The Privacy Shield was only an agreement between the US and Europe on how to treat the transfer of European citizens' data to the US territory. Here we are speaking of a regulation that goes beyond the national laws of the 27 countries in Europe. Big fines, 20 million euros, or 4% of the turnover. We may want to debate after my keynote about whether the fines are the bigger threat for companies or whether the power that the European Commission has to stop immediately the data treatment is the biggest threat. As far as I'm concerned, I think that the biggest threat is to force you to stop the data treatment immediately. What are the rights of the consumers? So first of all European citizens are equal, because that's a regulation. It has not to be translated into national laws. That's very important. So now we have some kind of common grounds for all different countries in Europe. And as I said, foreign firms, whether they are based in the US, in Asia, or in other parts of the world, they have to respect GDPR from the moment they handle European citizen data. And one very important right too is the right to portability. So European customers have the right to claim their data back from you guys and to hand it over to another provider. So if I'm a customer of a bank, for instance, I can claim my data back and bring that data to another bank to get better deals, to get better mortgages, and so forth and so on. The right to understand what is going on. So if you think of Facebook, for instance, I bet most of you don't know how your data is collected, for which purpose, and what Facebook does with the data. Well, under GDPR, that is not permitted anymore. You have to inform European citizens about what you do with the data, what is the finality, how you collected consent, and so forth and so on. So you have to be transparent. Yeah? And the first thing to ask is what data you collect, what you do with it, how it works. Those are the questions that you guys need to address within your companies. Give me a break, that's another right that consumers have. The right to be forgotten, the right to erase all the data. So if I am registered in your databases and I contact you, you must comply with GDPR and erase my data if I ask. And you will have like 45 days to comply, or 60 days, that depends. Okay, and then what are the technical challenges for you? The first challenge is to be compliant in terms of privacy by design. It means that all your architecture, IT architecture, must be designed to respect privacy. For instance, is the data stored on an ISO 27001 server, which is a norm that ensures that the data is safely stored? Yeah? Do you degrade performances of your website, of your services, if people do not accept to be tracked? This is another question, and perhaps that should not be the case anymore. You have to inform people about, in a transparent way, about what data you collect. So those small letters that I showed here will not be permitted anymore. So this is something that I took from from terms and conditions of a Wi-Fi access point, and something like this will not be permitted. Obviously, that was a joke, but if you read the small letters, you will see that many companies, they hide some of their bad practices into the small letters that will not be permitted anymore, because you have to get an explicit and informed consent from the consumers you are getting data from. Let's play fair, responsibility and accountability. That's also something that you will have to comply with. So you will have to go through an impact assessment. And most importantly, you will have to minimize the data that you're collecting. So if you have no reason to collect a certain type of data, then you will have to stop collecting that data. So if you collect, for instance, Facebook likes through a Facebook Connect on your web pages, and you are doing nothing, or you have no reason to collect those likes or the list of the friends, then you have to stop doing that, at least for European citizens. If you have a data breach, you must comply with the law and report within 72 hours. And there is also a very interesting principle in Article 13.2f, which is the principle of fairness. And for those of you who are in New York, tomorrow there is a conference at the New York University on fairness, which I will attend and participate to. And the principle of fairness forces companies to be fair in how they collect data, in how they treat data, to respect people's general interest. So what is the organizational impact for you guys? First one is, well, you have to take the fines into account. So you may just want to avoid them. Remember, 20 million euros or 4% of your global worldwide turnover. If that's not enough, remember that the European Commission has the right, or the DPA, Data Protection Authority, has the right to stop the data treatment. Another very important consequence is that you may need a DPO, Data Privacy Officer. So whether that's someone that is in-house or whether that's a DPO as a service depends on the number of data that you're collecting from EU citizens. You will have to be more transparent, so it means you will need to review all your data collecting, data treatment practices, and question you about whether those practices are compliant with the law. And adopt, which is not bad, a code of conduct in terms of how you ensure that ethical treatment and equal treatment of all EU citizens is ensured. And obviously the data breach notification, if there is any security problem, you will have to report to the authorities of the country you are based in. With that in mind, I'm very happy to, I think we have time for a few questions. I'm looking at, do we have time for questions? Yeah, so I'm happy to take any questions that you may have. Thank you for your attention.
For companies that are headquartered outside of the EU, what agreements or
Could you just give a mic? That's pretty difficult for me to hear from. A second row from the back, gentleman with the blue shirt.
Is this thing on? Okay. Hi, Patrick Barnacle with M-Particle. What agreements or jurisdictional authority is in place to impose fines on companies headquartered outside of the EU?
Well, the GDP. Well, if you are in the US and you handle data in a certain way from EU citizens, maybe you will have to have a representative office in EU. And in that case, the GDPR will apply in the country where you have your local representation. So let's take, for instance, well, I have a few clients who have that case, and they have all chosen to be in Ireland. In that case, well, it's the DPA, so the Data Privacy Authority, which is in Ireland, that will supervise what you are doing, and that will contact you if there are any problems with the way you are collecting data, if there are complaints from customers. Don't forget that customers also get the right. Well, they had already the right, but that right will now be more severely enforced. Customers will be able to complain and to report data breaches, unethical treatment, bad data collection practices, and then you will be contacted by the DPA of the country where you are represented. And then you may be fined, or you may be forced, that's another threat, to stop immediately the data treatment, which may lead to bankruptcy, yeah? Because for some companies, data treatment is everything what they are doing. So if the commission tells you that you have to stop immediately, then you are out of business. And I know already two companies in Europe that are almost bankrupt because they are not complying with GDPR, and their customers do not want to take the risk to make business with them anymore.
So this is actually a great segue to our first panel. To help you better understand your risk exposure, especially U.S. companies with operations in the EU or trying to set up an operation in the EU to serve your EU customers. We have two more panelists whom I'll welcome on stage, one of which is from Braze, Susan Wiseman. She's the Senior Vice President Legal Counsel for Braze, which is from the perspective of you yourself as a company. And we also have Antonis Patrikios, who is a general partner at Field Fisher, a law firm that's really reputable in helping companies become GDPR compliant. So let's welcome them on stage.
Thank you both for being there. Very exciting session. Interesting also question that we may want to deepen during our discussion. May I kindly ask you, first, Susan, to introduce yourself, give a little bit of background about who you are, what is your experience, and then I will hand over to you, Antonis.
Sure. So I'm Susan Wiseman. I'm General Counsel of Braze. So we have been on a GDPR compliance journey. I could also call it a GDPR compliance nightmare for the last year or so. And so we're really excited to share today some of our experiences in the process of becoming GDPR compliant. So.
Hi, everyone. Good morning. I'm Antonis Patrikios. I'm a partner at the Privacy Security and Information Law Group at Field Fisher and head the firm's cybersecurity practice. For those of you who have not heard us, we're a fairly big practice advising clients around the world with GDPR and other matters, including in particular a lot of US companies. So hopefully I'll be able to share some of the insights we've gained through doing this.
Including us. So Antonis has been a wonderful partner for us in our GDPR compliance efforts.
I hope I wasn't the reason why you described it as a nightmare.
I was pretty surprised when Judy asked, when starting the conference, that so many people were actually already preparing for GDPR. I remember a few months ago, we had the same discussion in Europe with the Commission, and the Commission told me then that minority of companies had started with GDPR preparation, so less than 50%, like 6 months ago. So why is it important? Why are all these people in the room today, why do they need to comply with GDPR? What are the different implications for marketers, for IT guys, for lawyers? Could you explain it a little bit, Susan, please?
Sure. I think certainly from our perspective, we felt that from a commercial perspective as a company, that if we were not GDPR compliant on or before May of 2018, all business could come to a screeching halt. We felt that even though we're not located in Europe, we felt that our customers who are global in their reach would very much care about whether or not we were able to convince them of the fact that we had taken GDPR seriously and were prepared to enable them, when they used us, to be compliant with their GDPR requirements. I think that everyone who's in this room cares about it, because for Americans, I think it's a real a difference between how we have viewed our obligations as service providers in terms of how we process and control data, how we respond to requirements with respect to privacy rights. And I just think it's been a fundamental change in how companies in the US approach privacy. And so for us, I think, you know, speaking as US companies, I think it's scary when you think about the kinds of fines that are out there, and no one wants to be the company that gets hit with those fines.
Antonis, can we do business without complying with GDPR?
Yes, if you have nothing to do with the European market or with data. Is there anyone in this room who has nothing to do with the European market or data? Probably not. Look, to me, there's obviously Susan explained the specific reasons that Braze cared passionately about this, and I've made it part of my mission statement to make you all EU privacy enthusiasts. At some point, it's a bit of a tall order. But for me, there's basically two reasons why everyone should care about the GDPR. Number one is the obvious. It's the law in Europe, and it has extraterritorial effect, which means that it would capture most of you, certainly if you're providing services to EU individuals. It's the law. There's very significant sanctions for getting it wrong. We've all heard about the massive fines. Pierre Nicolas mentioned the power of EU regulators to require you to stop unlawful processing. And then there's some fairly significant consequences that perhaps have gone slightly unnoticed, because 20 million euro, 4% of worldwide turnover is such a headline item. But regulators also have powers to audit companies, and we think these are rights that are going to be exercised. So for the first time in Europe, at least across Europe, you have the potential of regulators just showing up at your doorstep one day saying, "Hi, I'd like to check everything now, please."
Do you think that they will be Do you think that they would show up in US companies, or do you think that regulators will stay on the continent? Just out of curiosity.
That's an excellent question. You have to remember what EU regulators are. They're typically very professional, but fortunately or unfortunately, depending on your perspective, under-resourced and under-funded. And as EU regulators, they have a duty to prioritize what they're going to go after. There hasn't been a single instance of EU regulators spot-checking companies in America. There was one instance several years ago where Italian regulators threatened to go to Silicon Valley and audit Google. I don't think that ever happened. But to go back, and that's an excellent question, it links to the question that the gentleman had earlier about the real risk of being enforced against if at least you don't have a physical presence in Europe. There's another potential which I think US citizens, especially lawyers, will understand. For the first time in Europe, the GDPR sets up the elements of what looks very much like a US class action regime. So in addition to the fines, in addition to the enforcement actions, in addition to the audits, we have for the first time in Europe the ability of someone, it could be an individual or a smart lawyer or a consumer organization, to bring claims on behalf of aggrieved individuals. And there's a lot of other things that are worrying in that respect, which I won't bother you with this now. So that was the first reason. It's the law, and you have to do it, or else EU regulators may be small dogs, but they have very big sticks now. The second reason is that, well, frankly, if you want, it's the data age. We all deal in data. And if you want to do business in Europe, GDPR is the law that sets the framework of what you can and cannot do. So over and above legal compliance, it is what would set the broad parameters of what you can do as a business. And in that respect, I think no one can afford ignoring the law.
If I may comment on that. So you're right on the controls. Don't forget that controls have already started. So controls in France, for instance, and in Germany have already started. Yeah, so the authorities are already going into businesses to see how data are being collected and how data are being treated. Now, on the threat side, I think, or would you agree with me that it's also an opportunity? GDPR is an opportunity because European citizens are more and more data conscious. So they care about their data. You just have to look about the polls in Germany, for instance, or in the Netherlands. And those of you who do business with Europe and don't care about data are wrong, because citizens of the different European countries will then see you as bad partners rather than good partners, and will just change or stop using your services. As I said, I know already 2 companies that are almost bankrupt because they are not, and European companies, because they are not complying with GDPR, and no one wants to do business with them anymore. So I think that's also a very big threat. But that being said, how does it differ from other privacy laws like Privacy Shield, for instance?
So, I mean, I think the scope of GDPR is so much broader than anything else out there. I mean, from our perspective, I think there's much more of a concern in the past or under the current framework, which is the directive. US companies will comply with it because they're contractually obligated to do so by the European companies that they work with. Under GDPR, it's a direct obligation of the US companies who are collecting data of European data subjects. But what I think is really interesting about GDPR, and one of the things that my experience has been, is that when I've spoken, we spoke in London last summer on GDPR, and we were in a room full of marketers and advertisers, and pretty much everyone there knew about it. And when I asked people, how do you feel personally about having control over your data? And pretty much everyone in the room felt very, strongly that this was a great thing for them to be able to have control over their data, to know who was collecting it and what they were doing with it. But when I asked them as marketers or advertisers, what did they think about GDPR? I think the answer was the opposite. People didn't like the idea. And I think that calls out one of the big issues right now with GDPR, is that, as Pierre has alluded to, right now, you can, do one Google search on cars, and then anywhere you go on the internet, if you go onto social media or any place else, you get all of these ads on cars. And so you know that your data is being collected and used, and you don't know how it's being used. I think for Americans, that's much less of a concern than for Europeans, who I think view GDPR or view privacy rights as a fundamental right. And so I think that really calls out a distinction. And one of the reasons American companies are having a harder time with this, because I think for them, privacy rights and this control over data is less of a driving force than it is in Europe.
Before I give you the floor, just to comment on that. So in my role at RTBF, I am required by law to answer citizens' questions on live TV once a month. So if you want to see me on TV, that will be on Monday. And one question that comes over and over is the question on retargeting. So that's something that not all of us are doing. That's a common practice, but that annoys so much people, and that makes data collection so visible that people are really getting sensitive about that. And to close the topic, what you also must know is that in many European countries, for instance in Germany, there are educational programs funded by the states to educate children and people on data collection practices. We are also doing that too in Belgium and at the EBU, European Broadcasting Union level from 2018, because we want people to be conscious about data that is being collected, how the data is being treated, and you must expect that that consciousness level will grow with time. So if you do not comply, you're just dead. Your viewpoint?
I think that's absolutely right, and you raise a very interesting point, which is leave the law aside for a moment, right? So what we're seeing in Europe very, very clearly is that people's perceptions and understanding around privacy is changing, and people do generally care about their privacy. And then we have these mega security breaches that sort of tend to reinforce that message on people's mind. So that's Europe for now, and there's very specific legal, cultural, historical reasons why we care so much about privacy. But Europe is a very big market, and what happens in Europe has impacts elsewhere in the world. And I think one of the consequences of the GDPR in the medium to longer term that we're going to see is twofold. Number one, it will influence legal regimes in other parts of the world, perhaps not in the United States of America, but think Asia Pacific, for example. They tend to take the lead from Europe. Second, and most crucially, I think that perception that's changing in Europe, as far as how individuals think about privacy, will have knock-on effects in other parts of the world, and people will start caring about their privacy more in other parts of the world. Just to highlight an example of how this plays out now with companies with whom we're working on GDPR readiness, right? Think of your HR data, think of your customer data. GDPR says in the EU you have to give people all these rights, all this choice, all this transparency. Great. You don't have to do it in the United States of America. But you, as a business, are you prepared to explain to your US employees or US customers why are you giving all this choice to EU consumers, but you don't give it to the US people? How do you justify that? And some clients say, well, pretty straightforward. I have a legal obligation here. Don't have it over there, so I'm just going to do what the law says. But others are thinking about it from a customer engagement and PR perspective, and are just concluding, well, I can't really justify it. So if I give all that choice to my EU customers, I'll also give it to my US customers because that's what they expect me to do. So it has already impact in changing the culture over and above what the law requires.
You know, what's interesting is complying with GDPR requires that you are protecting and giving all these rights to data subjects who are EU citizens. But how do you know someone is an EU citizen? So there may be someone in my office who is American, but actually his parents are both Irish and he was born in Ireland, but he's been raised in America. We don't know who is a European citizen. So at Braze, we are treating everyone, every data, every piece of information we collect, we're treating everyone as an EU data subject because we don't want to make that mistake inadvertently that we haven't protected the rights of an EU citizen. So we just have gone to the far end of that and said that we're going to comply with respect to everything we do everywhere in the world with every person whose data we're collecting. And that's kind of how we've approached that.
And I must say, well, 2 years ago, well, because as a chairman, I have the privilege to observe practices in more than 50 countries. And 2 years ago, when we first heard about GDPR, I thought that the practices that will develop will be more like, you know, like in the UK, where people, just like in the US, are not so data conscious and well, the UK has always been in advance in terms of how much data they collect and what they do with it. And it's quite a reverse that has happened. It's actually Germans and French that are now paving the way for more consciousness, and all other countries are just following. I think that's a very important trend to consider, that ethics in doing business and having common grounds about how you treat data, whatever data it is and whatever the citizens come from, is very important.
We also think at Braze, and we began our GDPR compliance efforts long ago, like over a year ago. We took the view that if we want to be able to do business, that we need to be GDPR compliant, and we think that there's a competitive advantage. We think that being able to tell our customers that, yes, we take this seriously, we understand the obligations of GDPR, we have re-architected our systems, we are prepared to enable you to do this. We think that's really important, and that companies in America need to take that perspective. I think Antonis probably has a broader view of this, since he advises so many different types of companies across so many different fields. Yeah.
So you started 2 years ago, but for those who have not yet started or are just in the very starting phase, what do you, Antonis, think they should do as a first step to be compliant in less than 100 days?
Start tomorrow morning. So if you have not started, 3 things. Number 1, there's no way you're going to be ready on time unless you're a very small company and all your systems are in order and you know exactly what you collect about whom and when and where it goes and all that kind of thing. Second point, what you need to be doing now is start with your data mapping. So start, if you don't know what data you have and where it goes and what you do with it, you don't know what data you collect, start now with mapping. And then what you need to do is put a plan in place for getting ready. Don't get bogged down on the, well, I'm not going to get ready by the 25th of May, so might as well start next year. Unless you work for one of a small handful of very high-profile internet companies, chances of EU regulators looking into your practices anytime soon, short of a very serious security breach, are very, very small. So what you need to be doing is get on with it, make sure you have a plan in place, work with your advisors to identify where are your real tricky issues, your difficult issues that might actually either impact your business or get you in serious trouble, and have a remediation plan in place. Don't focus so much on getting ready on the 25th of May. Focus on understanding what you need to do and fixing the tricky problems by then, and then you can sort out the rest later.
Well, I can give you one insight from at least 3 countries where I've been in contact with. The DPA there, well, they think they will make some examples. So starting in May or in June, they will look for the big fishes and they will impose some very important fines. And then most probably it will be quiet for like a year and they will start again next year because, well, investigations will take time. And what you also should know is that DPA, so data protection authorities in the different countries, are building up capacities. They have been understaffed for years and they are recruiting massively people to investigate cases. Yeah? So if you are safe, let's say, if you are not a big fish, you're probably safe this year, but next year, well, they will have built up capacities, people will be up and running, and they will search in all directions to find bad practices and stop them.
Yeah, can I just throw in another sort of idea in here in terms of managing your regulatory risk management, yes, they're upskilling. There's very clear signs. They're recruiting. They're upskilling. They're cross-pollinating, big time. But the GDPR is a big pain on the back for business. It's perhaps an even bigger pain on the back for regulators, because, as we said, they're understaffed. They have to enforce and supervise and enforce this. And they have this beautiful baby called 72-hour breach notification that's coming their way. and we expect they'll be overtaken by a tsunami of breach notifications that they'll start receiving. So it's not as if they're going to have spare capacity and they would just sit there and say, what should we do tomorrow? Let's pay a visit to Braze. You know, it's just not going to happen that way. I would say if you guys have ongoing challenges, let's say, with regulators in Europe, I'm pretty sure you will have started looking at your GDPR readiness already. If you do not have, get on with it. As we said, the chances of someone paying you a visit is probably small, but there could always be that trigger that you do not control that might bring you to the attention of regulators. Seen it time, I've practiced in this area for 11 years, seen it time and time again. It takes one security breach or one person to go to one regulator and complain. It could be a complaint, it could be a rogue employee, it could be a disgruntled consumer, it could be whatever. And I've seen it time and time again where you have one tricky consumer, no grounds whatsoever, but because they've gone to the regulator, the client comes to us, pays lawyers' fees to handle this properly. It can be tricky. So to go back to the first beginning, if you haven't started yet, have a chat with your advisors, see how exactly the GDPR affects you, and if it does affect you, get on with it and put a plan in place.
One of the things that we haven't mentioned, which I think is worth noting, are, well, two things. One is that the people who wrote GDPR don't really understand technology. And that's certainly one thing that we have focused on a lot at Braze, is that there are requirements under GDPR that technology just doesn't do. And so I think what we're seeing, certainly contractually, is people saying that you will comply with GDPR to the extent feasible. Because I think the other point I wanted to make is that how GDPR will be interpreted and what a lot of these requirements actually mean in a day-to-day way is not really clear yet. So the authorities are coming out with these pronouncements where they're talking about, you know, what do they really mean by consent? Who has to hire a DPO? And so they're trying to answer some of the questions that people have, but I think in terms of how GDPR is going to be enforced, what do they mean by certain of the provisions, and are certain efforts that are being made actually sufficient to meet the requirements? I'm not sure that's clear yet. And I also think certainly for technology companies, you can only go so far because there are things that technology just can't do today. And so that makes it very challenging. And that's one of the reasons I think, going back before, is why are we so afraid of GDPR? And I think that's one of the reasons. It's very hard for us to wrap our arms around all of the requirements under GDPR.
But I think it's actually good that they did not define everything. Yeah? Let's talk about consent, or let's talk about data portability. I had the opportunity to ask the EU Commission director what data portability means, and he said, well, you have to define it yourself within your industry, so it was not defined. But I think that's an opportunity. If something is not defined, then make it your way in the best interest of the consumers. And I very much agree with you, Susan, when you say that it's an opportunity. It's not a threat. Yeah.
It's funny from that perspective that you say that it's an opportunity, because I think of it as a big giant stick that if you get it wrong, you're subject to fines, you're subject to all of these penalties. And so from the perspective of an American company that's working very hard to be compliant, I think that the fact that things aren't clear makes compliance scarier. And I don't think it's a good thing. I think that that's a difficult thing, at least from the perspective of a company that wants to do it right, is working very hard to do it right.
I think that's absolutely right. So it's both, actually. It's both a risk and an opportunity. A risk for the reasons that Susan explained, an opportunity for the reasons you explained. And let's not forget, not everything is bad in the GDPR. So we have some really interesting concepts in there. There's this idea of accountability, which at a high level basically means each company is responsible for setting out how exactly they will go about complying with the principles of the law. And that gives you quite some leeway, especially in grey areas. Say, well, in my case, I comply with the transparency requirements or the record-keeping requirements or whatever in this way. And where the art is, right, and where your advisors, especially your legal advisors, can help you, is to tell you Where are these red lines that you absolutely cannot cross in determining how about you're going to comply, right? To give you an example of what I mean, thinking about the simplest of requirements, the GDPR says, as Nicola told us, you have to be transparent with people about what you do with the data. Great. There are some things in there, and there is some regulatory guidance that's so prescriptive that basically says, oh, as part of complying with these requirements, you need to list each and every service provider that helps you with the data. For some of our global clients, that may mean 2,000 companies. It's a long list that simply getting it together and maintaining it is very difficult to achieve. So here's what I mean when I say you can actually be flexible as to how you're going to approach it. So long as fundamentally you're confident that what your privacy notice does is it very clearly explains to people, here's what data I collect about you, here's what I do with it, and here's what rights you have. And then for a narrow technical requirement such as listing all your service providers, you've been creative in the way in which you're going to comply. For example, you do not list everything in your privacy notice, which would be pointless. You provide a link to your website where you have a list that you update every now and then. So, and even if you don't manage to comply, you restrict your non-compliance to a narrow technical point that's unlikely to land you a 4% of worldwide turnover fine.
No,
if on the contrary your intentions are wrong, and what your privacy notice does is it basically tries to pull the wool over the eyes of the consumer so you can do whatever you want with the data, that's definitely something that's likely to get you in serious trouble.
well, if you have 2,000 suppliers of data-related services, it may be time to well, go through them and kind of reach economies of scale and get rid of some of them. Yeah? That's why it's also an opportunity. Is it time now for question and answers? Yeah, it's time for question and answers. So thank you so much, both Susan and Tony, for your answers to my questions. And now we will take a few questions from the crowd. The gentleman here on the first row.
Okay, good morning. I want to say thank you for sharing your wealth of knowledge with us. I'm Hector Munoz, coming from Boston. I'm GDPR consultant. And my question is, take in consideration, and don't take me if these numbers are right, but according to the Gartner study report, I think about 60% of American companies are not ready for May the 25th. So what's going to happen with the GDPR initiative? This is going to be an ongoing process. It's going to be more things coming up after 2018 as a career. You know, we definitely would like to know. And this is going to require for companies in America to be monitored on a yearly basis, just like we do the IRS, the taxes, right? An example. So I think this is going to be a lot of work coming up, and I think it's going to require to monitor, even though they're in compliance now, but what happens if they are not compliant next year?
Well, absolutely. I mean, I think one of the difficulties is if you want to hire a vendor and you want to check out their security, you can see, do they have a SOC 2? Are they ISO 27001 certified? But there really is no way to tell if a company in the US is GDPR compliant. And that's one of the things that actually we're going to go into some detail on later in the IT workshop. We do want to talk about that in some detail, but I mean, I think that that is a challenge, and I think that you can have conversations with companies and get a really good sense of how are they viewing GDPR, what have they done to become compliant with GDPR, what are their practices, what are their policies, and I think you really do need to ask questions. I think that, you know, certainly Braze has a number of things on our website that show our GDPR roadmap, what we've done we have an FAQ. And so what we're trying to do is we're trying to show companies where we are in our GDPR compliance roadmap, and I think that that will become best practice. That's certainly our intent, is to show and be really transparent with companies, which is one of our values, is that we need people to know what we do and how we do it.
So it's not mandatory for companies to report on a yearly basis where are they in terms of GDPR?
Attestation, no, it's not mandatory yet. It is something that may happen in the future, but not yet.
All right.
But that would be a good practice. I mean, to review on a yearly basis where you are, what you are doing with the data. Actually, if you are not doing it right now, that's already wrong.
Well, the whole concept of privacy by design, I mean, I think that either you are a company that has taken GDPR really seriously, and at the highest levels of the company and throughout the company, you have excuse me, you've automated processes so that you can be GDPR compliant and that you can show. We certainly are at the point now where we have a number of companies and customers and prospects who are doing a very deep dive into what we have done to be GDPR compliant. And so we feel that that will continue, that people are going to want to make sure that, that what you are doing with their data is what you're supposed to be doing under GDPR. And we think that people should be asking those questions and that the companies you work with should be able to answer those questions.
Thank you. We have a second question or a third question. So first.
Sure. We also have a question from the live stream. Are those early complaints, and this is for you, Pierre, are those early complaints, the two companies on the verge of bankruptcy, coming from individual consumers or B2B clients?
Oh, that's coming from B2B clients. So the companies I am thinking about, and obviously I cannot give their names, are data brokers. And they are not able to show to their clients, so retailers, banks, insurers, how they collected consent. And as a consequence, those retailers, banks, and insurers, they just say, well, we just want to be risk-free and we will stop doing businesses with you because we do not want to be contaminated by your risks. So they just stop. And if you think about the example that I gave when starting the keynote yesterday, so when I took that coffee in Soho and I got a commercial email, because I had to give my email address to get the receive, I did not give consent. And yet, I got that email. That's wrong. That's wrong. That's unlawful.
Hi, my name is Matt. Question that came out of the keynote with respect to the principle of minimization. When you talk about at heart not collecting data you don't intend to use, I guess my question's in two parts. One, has there been any guidance around what usage means? So if you're effectively using it for internal business analytics and successful campaigns, is that sufficient? And second, how about the concept that you might be collecting data with a future purpose and you have a bona fide intent to use it, but you're not actually using it at the time that it's being collected because you don't have a sufficient sample?
So I can answer that question, but I would like also to give you the floor.
Throw it to the lawyer. So 2 points. One, the good thing about the purpose limitation principle and data minimization is it doesn't prescribe what you can and cannot do with data. So long as you have a valid, legitimate business purpose to collect data, you can do this. Okay, so that gives you an amazing degree of leeway as to what you can collect data for. And yes, internal business analytics, clearly a legitimate purpose. Making money, clearly a legitimate business purpose. But it has to be legitimate. It has to be a purpose that you've established and communicated to the data subject, and it has to be a purpose for which you're using the data now. You can't collect data just in case you may need it in the future.
And just saying that you will do something with the data in the future is not a legitimate purpose.
It wouldn't be, unless what we're talking about is I want to collect it now because in 3 months' time, this big data analytics project kicks off or whatever it may be. So it's let's say, clear and present purpose that you will have, just hasn't started quite yet. But basically collecting data because you think you might move into an area and you might need it, that simply won't cut it in terms of the data that will be caught by GDPR.
And one very important thing that Anthony said is you have to get consent. So you have to explain your future purpose. So if you fail to explain that, and if you fail to get the consent for that purpose, it's unlawful.
Can I just intervene here because I'm slightly concerned that we may be creating an impression that whatever you need consent from people in order to collect any data from them and do anything with it. That's just not the case. Consent is one of many grounds provided by the GDPR on the basis of which you can process personal data. You don't always need consent for any data processing. There are some things such as marketing, for example, as Pierre said, where the law, interestingly, not the GDPR, we have another law in Europe, and please make a note of that piece of legislation because it's being revised and it's going to have far-reaching implications for marketing, online tracking, and other things, especially if you're a telco, called the e-privacy directive or e-privacy regulation, as we'll have soon, that basically says for certain things you need consent, such as marketing. So for those cases where the law says you can only do this on the basis of consent, then you have to obtain consent. But for most types of data processing, including analytics, for example, the law does not say you need consent.
Absolutely true. We have time for one more question, one last question here at the back.
Hi, can you tell me how this the GDPR might relate to employee-specific data? So my company, we don't actually collect data from consumers. We sell it to a company that their employees then log in, and only the employees of that company specifically use our software. So, we store their email address. Is that considered personal data that has to be treated the same way as? Yeah.
Are there employees that are European citizens?
Yes. Yes.
Yes, okay. So then GDPR does apply to that situation because you're collecting personal data. And under GDPR, the definition of personal data has been expanded tremendously. So under the current law, which was written over 20 years ago, how we were able to identify people was much more limited than how we can identify people today. And so the definition of personal data is so broad under GDPR. So if you are collecting, which you are, if you're making decisions about the data that you're going to collect, and usually most companies, when they're talking about an HR context, they are talking about themselves as data controllers, even if in another context they could be a data processor. So GDPR does apply to your situation.
Yeah, email address are clearly personal data. I mean, just since we're on the topic, things like unique device identifiers or IP addresses are personal data in Europe. So very, very broad. That's clearly the case. And then if I think what you're saying is you provide some form of SaaS solution and you have employees of your business customers logging on, and as a result of that, you require them to give you some data, and probably, may I add, you also track what they do with your software so you can improve. These activities would clearly bring you in scope as a controller, as Susan said, so you're caught. Then, in the interest of giving practical advice that sort of positions you in a risk sense in the best possible way, is it just that your company does, in which case we can restrict your GDPR compliance to that particular aspect, or as a result of doing that, then let's say, it's probably an unfortunate parallel to draw, but GDPR spreads and actually infects more of your organization, in which case you need to do more things.
So we will have to close here. So just a quick sum up, like in 2 or 3 sentences. So everyone is concerned by GDPR from the moment that they collect data from European citizens. Consent is very important, so you have to get consent for a certain range of purposes, so not everything is covered. Maybe we can discuss this in the marketing workshop afterwards. Data breach notifications we have spoken about. And with that in mind, I propose that I hand over to Julie. Thank you very much.
Well, thank you very much for sharing with us your experiences. I hope you have a better understanding on kind of your risk exposures and the scope of GDPR and how to try to avoid getting into trouble with GDPR. So the next panel will talk about what kind of action steps you can consider implementing right now, since we have 100 days, less than that. We have put together a panel, a diverse panel, from different types of companies, as well as people who lead different types of teams within these companies. We have Ben Hoxie from mParticle, who leads the head of product development. We have Kate Hooker, who is the head of legal at Greenhouse Software. And then we have Fouad Khalil, who is the head of compliance at Security Scorecard. The panel will be moderated by Melissa Adelet from Braze. Let's put our hands together for them.
How's everybody doing? That last session was really fantastic. I learned a lot, I think, for our own team as well. I'm Marissa Eidlet. I lead marketing at Braze, and we're in a very interesting position where we're both having to become compliant for our technology company, but also on our marketing team, we really have to think about marketing in a completely different way. So I'm extremely excited to have this esteemed group of panelists up here with me to talk about the approach to GDPR and how you really get started. Now, this is something we've learned a lot about as we've talked to many of our clients along the way. And we've learned a tremendous amount, but I've learned even more as I've talked to these folks here. So I'd love for them just to introduce yourselves. We have Fouad. Why don't you start and just talk to us a little bit about your background and
Sure.
Go to the next one.
My name is... Can you hear me?
Push that. You should be good.
How about now? All right. My name is Fouad Khalil. I'm the head of compliance at Security Scorecard. My background is compliance, compliance, compliance. I've actually been touching up on many frameworks, many audits, and had fun from HIPAA to SOX to now GDPR, ISO, and the like. I'm a proponent of the deep dive as GDPR is bringing forward to organizations simply because of compliance by design. The fact that you implement continuous compliance as well, keep auditors off your back. So I'm excited to this conversation and looking forward to some good ideas and suggestions.
Hi, everyone. Good morning. My name is Ben Hoxie. I'm the Director of Product Management at mParticle, and I've been leading our efforts to build features to support our clients around GDPR.
Hi, everyone. I'm Kate Hooker. I lead the legal department at Greenhouse Software, which is a HR tech platform. And yeah, I've been working for a long time on GDPR, sort of what Susan was saying in the last session. It became very clear early on that this was going to be a very important issue for our customers and a competitive advantage for us. So that's why we've been focusing on it.
Great. So I'd love to talk about philosophy first. Everybody has a different approach to the way that they think about GDPR. Ben, why don't you start and talk to us a little bit about your philosophy at mParticle and in your particular role and what you're really seeing?
Yeah, sure. So mParticle, for those who don't know, is a customer data platform. Customer data is sort of the lifeblood of our business. And so with regards to the GDPR, we approached it from two macro angles. One is how do we become compliant for cases where we're the controller, for marketing targets and sales targets and things like this, and then how do we build features to support our clients' compliance for all the customer data that we steward every day, supporting them through things like we've announced new features around consent management and some features to help support the rights of the data subjects for access and portability and erasure. In terms of philosophy, I personally love the GDPR, and I'm happy to be in a position as not a broker, but a middle layer of customer data to really push the envelope of what can the technology do to support compliance.
Okay, what about you? What about your philosophy at Greenhouse?
It would be tough for me right at this moment to say I love the GDPR, yeah, I mean, I think we're actually in a somewhat similar position, it sounds like, to mParticle in the sense that we are, and I don't know if this was covered in a prior session, but like the difference between a data controller and a data processor is a big distinction within the GDPR, and we sort of occupy both roles. We, have our marketing contacts and our sort of like sales CRM and stuff, so we collect data from prospect customers and stuff in the EU, but then we also manage HR data that comes from our customers in the EU that is, applicants who are data subjects. So we had to do this sort of bifurcated approach where we're, becoming, Greenhouse is becoming compliant in its own right, but then we also had to build out features, talk to our customers, figure out ways that we could help them with their compliance obligations. And it's been really interesting. One thing that I would say I love about it is it's enabled me to work with, it really touches every department in our company at this point. And so I've, had to collaborate a lot with product, which I hadn't been doing as much. And now that there's sort of like a privacy by design mandate, I imagine I'll be working with product a lot more in the future. And that's been great, so.
And Fuad, what about your philosophy?
From a practitioner perspective, we've all been through the Sarbanes-Oxley and other frameworks, and then HIPAA, high-tech came on board. They come as tidal waves hitting us, forcing us to do changes and implement controls and scramble to become compliant. But if you think about it, it gets you to a point where you are in a comfortable place. You have controls, you can answer to auditors, you can provide assurance to your customers that your data is protected, the processes around it are secure. End result is good for everybody. There is the occasional milestones or pain points where auditors come knocking saying, show me the evidence, and the unfortunate mishap of data compromise or potential compromise where you have to explain it. In the same token with GDPR, there is a good tone to it. Eventually the data will become more accurate, will become more locatable, so to speak. The controls will be quite efficient around it, and it's good for business. So there is a positive twist to this.
So it can be very overwhelming. I heard a question asked, I think that was up here, just about how prepared companies are today. And I'm sure many of you in the room have either been working on it for a long time or you're here to learn more about what you should be doing. One thing that I think is always difficult when you go back to the office and you still have everything else that you have to do, how do you prioritize is something I think about a tremendous amount. So I'd like to know from you guys, what do you prioritize first on your journey to become compliant? You want to take the first one, Fuad?
Sure. I look at these initiatives as from a compliance perspective, you have to have a process background. It's a process improvement initiative, okay? So you need to figure out what all the requirements driving you to implement GDPR. Based on that, and it's all risk-based, so you have to follow the data through your organization. The way I like to do this is you put your chef hat on and you put a little bit of a Sarbanes-Oxley, a little bit of a security breach legislation, put some steroids on the definition of PII, and add to it some online identifier information. It's the same thing, but it is a little bit complex. So as long as you follow the letter of the law in terms of first, where is your data? How is it being processed? Where is it being housed? And where is the final resting place before deletion? That's a great start. At the same token, you have to have management commitment from the top down, as well as you have to have complete awareness of the program. So to sum it up real quick, know your data, be ready for the controls, ensure management commitment, and make sure everybody is aware of what's coming and when.
So start with knowing your data. It's critical. What about you, Ben? How do you prioritize?
Yeah, I think they made this point on the last panel, which I'll reiterate because I agree with it so much, is that the best thing to do to start is to do an impact assessment, right? Part of the impact assessment is to write down what you collect, what do you do with it, where does it go, why are you using it, really you have to start sort of swimming in the personal data that you're collecting and processing. I think alongside that is to build a committee of internal stakeholders that can work on it. And I think the last thing that I would suggest in terms of prioritization is if it's confusing or if you're swimming in legalese, then you may need legal help to help interpret it and apply it to your company. I think those three things, maybe that's too much, and then again, then you're compliant, but I think that's a good start.
Yeah, I totally agree with what both of you guys said. I think the most important thing is getting a real handle on your data, and also, speaking as a lawyer, like for me, one of the biggest things I've had to do is get a real handle on our, vendors and our customers, and make sure that our contractual obligations with both are sort of up to date and enter into DPAs where necessary. And so it's just like an idea, it's like having sort of a picture of the entire universe of the data that you handle, where it comes from, where it goes, is the first thing you need, because you're going to start the other steps and then suddenly I guarantee it, or at least in my case, someone is going to be like, oh, well, what about this vendor that we've been sending data to? And you're like, wait, what? No one ever told me about that. So, I think if I could have done it over, I would have gotten more people involved earlier on and made it sort of more of a company-wide initiative where everyone's on board and everyone understands exactly what we need to know. Instead of trying to keep it among sort of a few key stakeholders, because it really is something that extends throughout the entire company.
That's actually a good segue into my next question, and you had mentioned this a little bit in the last response you had around the teams that you work with and how closely you've been working with product. This just touches so many people within an organization, and all of you guys have been working on this for months and months and months. So I'd love to hear from you a little bit more, Ben, on how you guys have approached this internally. What teams are you working with? What's your philosophy behind that? And then, Kate, I know you've got some thoughts on that. I know, Fouad, you do as well, with recommendations on who else to bring in.
Yeah, sure. As I mentioned, the business of mParticle is in personal data, and so when we set out to think about GDPR, we really split it in half. So first of all, to answer your question, we sort of started this working group, and it included folks from marketing, it included folks from HR, included our COO, it included engineering and product. Did I leave anyone out? Client services, of course, sales. So we really got representation from a huge swath of the business. I shouldn't leave out legal, of course, legal. And we divided it in half. So half of it was about how do we become compliant for the data processing for which we're the controller. So this is data for which we define the collection and purpose. And then the other half, which I've been a bit more involved in, is because our business is in stewarding and distributing our clients' customer data, how can we sort of read the tea leaves of the regulation and try to figure out where the industry is going with the end goal of building product features into the platform that support our clients. So trying to push the boundary, trying to lead a bit in terms of if we have the data subject data, can we add consent to that? Can we do intelligent things with the data routing and forwarding and things like this? Was that an answer?
Yeah, no, that's helpful. You meet weekly?
I think it's every 2 weeks.
Every 2 weeks. I got a call on the way here this morning from our head of demand gen, worried that he wasn't going to be able to make our weekly GDPR meeting because we're all going to be here because we take it very seriously. But I mean, meeting as a group really helps, and we have a good shepherding system with an executive sponsor and a program manager on our team. Kate, you work really closely with the product team. Who else do you work with, and how do you kind of think about implementing this as you pull together these working groups?
Yeah, I work with the product team in the sense that, as I mentioned earlier, we are building a lot of features to help our customers with their compliance obligations, and that's been, the product team has been great and just sort of run with the things that we need to do. And I'm also working very closely with our information security team. I'm really lucky in that we have a fantastic engineer who heads up that department, and he and I are sort of like the people who just are constantly screaming at everyone about the GDPR, and it's been really helpful to have him. And then marketing is someone that in sales I've been working with a lot more recently, and honestly, and customer success. Because they have to message what we're doing, and they are fielding questions all the time from customers. So it really is like an effort that goes throughout the org. And I would just add, too, that we have a great outside counsel who's located in the EU, which has been really helpful because, as I think others have said, this is a very wide-sweeping general law. And it just isn't immediately obvious always how it would apply to your company's specific situation. And even, outside counsel who does this all the time doesn't always know exactly. There's some guesswork involved. So it's really imperative, I think, to consult a real, expert on this, and make sure that the approach that you're taking and the philosophy that you have is reasonable and one that will work.
And right for your business, because every business has such a different approach, and you're in a very unique spot being both a processor and a controller,
Right.
Fuad, you have a lot of different thoughts on this. You've obviously worked with a variety of different folks. Who do you think needs to be involved in the process of becoming compliant and consistently, following all of the regulation?
As I mentioned earlier, it's a process, okay? GDPR does not mandate data mapping, but they mandate data protection impact assessment. How am I going to assess the impact of my data without knowing where it is? So first up, by identifying data mapping activities, that will tell you where the data resides, what state, how it's being processed, and who owns or touches that data. That is going to drive all the divisions that are in scope of your GDPR implementation. In most cases, it could be the entire organization. And let's not forget, your data is also transitioned to suppliers and vendors, so that realm has to be also within scope. We can't forget about the outsiders touching our data, processing our data on our behalf. So you're going to find yourself looking back and saying, okay, I have all this data, I have all these different groups. So by implementing a project, that your direction is simply being GDPR requirements. And how are you going to minimize risk to data that is residing in different repositories, processed by different applications, and owned by different departments? That becomes a straightforward project that gives you the risk-based, which is what GDPR is all about, in my opinion, gives you the risk-based approach to minimize the risk and make sure that the data is safe. The one thing I always keep in mind is, if an auditor comes knocking on your door, what do you have in hand to satisfy their questions or what they're looking for, or at least show progress towards compliance?
So Fuad made this point earlier, and I thought it was a great way of thinking about it. So I just want to underscore that last point that he said. Where do you get started? How do you think about it? Well, if an auditor came to your door today, what do you have to show for it? What have you thought through? And that's a place to start. Just getting ready for that is critical. So I want to talk a little bit about the challenging parts of this. You guys have obviously mentioned some of that. Working across many different teams can be challenging. So I definitely recommend regular meetings and project management systems, and really getting everybody in your org sold into it is the key piece that helps you be more efficient afterward. I want to know about challenges, though. This isn't easy. Kate, you've been working on this for months. Tell me about, a challenge that you've had and how you've kind of solved for it as you've started to implement this change.
There are continue to be challenges all the time. I think it's just so much. There's so many things that have to be considered and thought about. And again, it's not like the actual piece of legislation gives you like a precise roadmap in each instance. So you'll be thinking about something through one lens for, a month or two, and all of a sudden you're like, wait, no, that isn't actually right. We are actually controlling some data that comes in through that way. We're not just acting as a processor or whatever it is. And so that has been challenging. And I guess the thing that has helped, and I don't know, I've been to a bunch of panels like this, and someone always says, and I find it helpful, is just we're kind of all in this together. Like this is a real big blow and big change. And like certainly as a lawyer, it's not, I don't know, I just feel like we're sort of trained to be like, we know what the landscape is and we're either on the wrong side of it or on the right side of it. And it's very sort of secure in your knowledge that you're complying with the law. And this one feels a little more wild, wild west. And I think the important thing is talk to other people, come to things like this, who are grappling with these issues, and see that everyone's sort of figuring it out, and find some experts who can really, you can do a gut check with. I actually went to a panel like this and heard a lawyer speak about the GDPR at a time, it was over a year ago, when I was really didn't know a lot about it and was really scared by it. And he just made everything sound so clear and practical and understandable that I was like, oh, I need to hire that guy, and I did. And it's been a really great experience working with him, and I think as everyone learns more and more about it within your org, like everyone wants to help and everyone wants Greenhouse to be compliant, and it's a common goal within our org too. And so, you just have to sort of campaign a little bit internally and get everyone understanding how important it is.
Ben, what about your challenges? What's the most challenging thing?
Yeah, I think you make a great point. For me, the hardest thing is the blessing and the curse of the vagueness of the legislation, in that it really is about intention and about a new way of thinking about personal data, but it doesn't prescribe really what to do in a lot of cases. The last panel talked about the umbrella of reasons for legal processing. I think there are 6 of them, and so there's a bunch of vagueness there about which do we pick and how do we do it. And I think the fun part about these kinds of events and these kinds of discussions is that this is the industry figuring it out, right? This is us trying to say, this is how we're interpreting it within the spirit of the law, and this is how we think is a reasonable approach, and this is what we need to do. And because it really encourages everyone to build their own approach for it. It doesn't say you have to do this and then you're good, which I imagine is tough for a lawyer. For a product person, it's like kind of fun because there's a little bit of room to swim to say, oh well, here's how we build a flexible solution, or here's how the options might shake out. And so it's the vagueness is definitely the hardest thing, but I don't know, maybe is it rude to say the most fun? I don't know.
Well, most fun and most challenging. Sometimes challenging can be very fun. You guys were talking a little bit about the right to be forgotten earlier. I'd love to hear a little bit more about that as a challenging factor for brands. Could you talk about this, Fuad?
Continue down the path of challenges.
Yeah. Yeah.
You don't know what you don't know. So statistically, I'm seeing some numbers where a lot of organizations are not ready for GDPR or have not even started GDPR compliance programs. That's a huge challenge, I tell you right off the bat. In addition, when you look at that, if you don't realize how mature your privacy programs are or how effective your internal control framework is, you might be halfway there. So the best step to do is figure out what you have in place now that will bring you closer to compliance, and then leaving you the remainder of steps to get there. So I've seen data mapping is the biggest challenge. Mm-hmm. Where is the data? How much of it is protected? How much of it is being processed, and by what? And what is the state of different data at different parts of its life cycle? Also, the big question about data protection officer, mm-hmm. that role. Mm-hmm. I've seen basically the description of that role. That person should be a superstar. They should be legal background, security, privacy, compliance, and on the like. Good luck finding them, because last number I heard, they were looking to hire about 28,000 DPOs by May of this year. So we need just 28,000 of those superstars. And last but not least, it is a process, a project. So if you don't have the resources in place to make sure that things are getting done timely, so work back from effective date to today and make sure that your plans are leading in that direction. Hopefully you'll get a day where you can sleep a little bit better. If I'm an auditor myself, even if you're not at a point of compliance, but you show progress, you show somebody's name on that effort, and you show a deadline or a date when that is going to take effect and satisfy the law, is a good step. Versus knowing there's a risk and an issue, and you're not taking any action towards that, then that could be a different conversation.
All right, well, I'm going to jump to the question about DPO then. So they're a hot commodity. What's your advice on how brands and companies should approach finding somebody?
If you're a
or
large
appointing somebody in their org, rather, right?
If you're a large organization, can afford it, go find the superstar. I've also seen a lot where they have a DPO function where different people put on different hats. So that function will be responsible for DPO responsibilities, which is probably recommended, simply because different people, different expertise, when they collaborate and work together, think the outcome is a lot better than one individual making all the decisions. Plus, the DPO responsibility, they own this data protection impact assessment. They own where the data is. They own the relationship with the supervisory authority. So having multiple resources executing that function is going to put you in a better place to plan, accommodate, and be ready for an audit, or God forbid, a breach.
All right, I'm going to jump into some rapid fire questions for everybody. And then I'm going to open it up for questions because I want to make sure that we have a chance for everybody to ask this amazing group here some stuff. So first rapid fire is, what do you know today that you did not know when you first started? Why don't we start with you, Ben?
what did I know today that I didn't know when I first started? You know, I guess every time I talk about this topic, I'm impressed with the maturity that the EU court system has. I know it was a long time coming, and you know, from the history in '95 to 2012. But like compared to American privacy law, I think it's pretty cool, and I'm upbeat about it.
What about you, Kate? What's one thing?
I learned a lot about engineering and data and where it goes. Like I was always sort of, I was like an English major. I am not an engineer. And I sort of like any other red-blooded American kind of like log into social networks and had never think about where anything goes. And it's been a huge education, like just a little company like Greenhouse, the amount of places where we get data and then where the sub-processors we use who help us provide our services. It's like an incredible web of companies. And then you look at like all of our clients are in the same, or all of our customers are in the same position. All of our vendors are in the same position. It's like, and it's amazing the size of it.
How big is your company? How many people?
We're at about 230 now, so.
Wow.
Yeah.
Fuad, what about you? What's one thing you've learned about GDPR that has helped?
Trying to get my grasp around what their definition of personal data is. I mean, living in the world of PII and PHI for years is much easier, but as you deal with GDPR and the personal data definition, it's everything. So my logic has been, when in doubt, protect. Don't question whether it's in scope, just assume it's in scope. Because you look at the data subject, and you look at the potential data elements around their information, everything you can think about, from a financial, personal identifiers, online identifiers, banking, social information, it's all in scope. And the tricky part is, in some cases, encrypted or not, may also be in scope of GDPR. So just to keep our arms around personal data is getting better, but I'm not there yet.
That's helpful. So we have a couple things up on the screen here, and I'm going to bring it back for another rapid fire, but I wanted to go through it because I mentioned this at the onset, and we wanted to pull some of the key takeaways from our panelists to give you guys tangible to-dos to think about, as you leave this conference later today and you get back into the office and you start to think about, where do I start? What do I do, right? And it's really important to think through and just start with that itemized list. To what Fuad was saying, having that checklist, thinking about it like you're doing an audit. What is that itemized list? And just pulling it all together, getting it all together. Then once you get it together, how do you understand where all the data is going and what it is? To Kate's point, she's learned so much about data moving in all of these places, and she'll uncover, a rock and see another bit of the data. So really understanding whether you're a controller or you're a processor and what that data is after you get that itemized list together. And then finally, documenting the ways that you're going to adjust and process and think about this in the future. I know that, our team, I'm looking right at our head of security over here, and, I had a list months and months and months ago of every single vendor that I work with from a marketing perspective, and going through and looking at who owns it, what data is collected, where the data is going, what we're doing about it. It's just really critical because you feel like you're in more control of what you need to do when you're organized around this. And I know at our company, so I'll start with my piece of advice and maybe we can go through. We believe so much in transparency and trust and making sure that, we're helping guide the way along this path. And, if there's the biggest bit of advice I can give, it's just understand where you're at today, so then you can start the path of moving forward to where you need to go. So what about you? What's a piece of advice for everyone?
Auditors trust everybody, but they simply have to verify the trust. Okay, so document, and document. Because when they come in asking, they're not going to ask for your opinion. They're not going to just interview you. They need artifacts. They need evidence to show progress, implementation, and evidence of compliance. So if you claim you do your data protection impact assessment on an annual basis, evidence of that should be there. If you claim you know where all your data and the associated consent is, you should have evidence for that. So trust but verify, document, and make sure that you're ready for the auditors come knocking.
What about you, Ben?
Yeah, I mean, I would say don't be afraid of the scope. I mean, it's huge, and don't get bogged down in some of the details of the scope, and instead sort of start to internalize the spirit of it. I think the impact assessment is the perfect way to start. I think it's what the auditors are going to look for, and the regulatory authorities are going to say, show me some evidence that you've done some diligence here. So that's the perfect place to start. But just get started.
Yeah, totally agreed. I think because of the fines and because of the scope and, there's a lot of sort of like hysteria right now. And, I have customers and prospects calling me all the time and they're sort of like hysterical is the word for it. And you go online and there's like a lot of misinformation being spread. So I think my biggest piece of advice is just like take a deep breath, approach everything, all the new information that comes at you sort of calmly. As I think the last panelists were saying, like, I think it's not the expectation that everyone is going to be like perfect on May 25th. But I think the important part is to show that you're taking steps, making a concerted effort, and have like made some changes. And that's sort of, you're halfway there at that point.
Can I do a show of hands in the audience? How many of you have already begun the GDPR process? Okay, and for those of you, how many haven't? How many are here to find out, where do I start? Thank you for being honest.
No
I am
shame.
sure there are several hands in here. So I know you guys all just gave some advice on where do I start, but for somebody who is here for the first time, just trying to figure out, oh my goodness, like what do I do? Is there anything else you'd share with them? I can answer first while you guys think about it, because I was thinking through as you guys were talking. Like campaigning and making sure everyone in your org understands the importance of it, I think has helped tremendously. We have a fantastic legal counsel. She has been campaigning and talking to us about GDPR for over a year. We all know about it, and we all should know about it even more, but that is a place that I think would really, really start to make sure everyone else understands probably the anxiety that you're going through as you think about how do I move this forward.
Yeah, I think one way to take the anxiety down a notch is to get started. We all talked about the impact assessment already, but I think having a common approach. So it's sort of like, yes, everyone has to be compliant, but you need to develop what does it mean for you. So for mParticle, I talked about these two splits, and we're trying to make it a competitive advantage. We're trying to add a lot of value to our platform based on it. That may not apply to everyone. Some companies may. Doing the minimum to be compliant may be the end, and that's great, and that works for you. Depending on sort of where you are and who your clients are and what your business is, you've got to have a joint approach to how do you want to approach it, because you don't want just to be scared and worried that you have to do everything in it.
Right.
You want to say, what does it mean for me?
Right, and finding the right partners, to your point, that are actually thinking about it is a huge component as well, because the more you're working with people that are on the same page, they can teach you along the way and be a true partner to you. So I'd love to open it up for questions. Got several here, so we'll take the one in the back first, and then there's one up front we can take.
How are you thinking about and how are you being creative about actualizing consent? And so on the product side, are we thinking about the old world order where a pop-up and closing a pop-up is sufficient for a user or a consumer? Or are we going farther than that with direct messaging and text messaging consent? And on the legal side and compliance side, how are you thinking about the level of detail you're providing a consumer that you're asking them to consent to?
I mean, so I think that this is one of the most interesting topics in the GDPR of lawful processing, and there's 6 reasons. I think consent is one of them. The other 2 interesting ones are legitimate interest and for execution of a contract, I think. Then there's a couple others, like to protect the state and compelled by the law and stuff like that that nobody wants to talk about. So I think really each company needs to look at the 3 reasons and say, what do we want our approach to be based on our uses of the data? So first of all, I sort of think that's the groundwork. Sorry, my preambles for GDPR. I think consent, it encourages consent a lot in that, it doesn't want everything to slide back into legitimate interest and have everything be buried. In terms of implementing it in reality, I think was your question, it defines the privacy notice and it defines a bit of guidance around how to articulate what gets collected and how it gets used and where it goes. And you know, I think so. If a company chooses to go with consent, I think that they're going to end up having to provide a few summaries of where does each type of data go, and you're going to have to say, okay, I was in the UK last week, and I saw my first one as an American on Google Maps, and it popped up and it said we need to talk about what we're going to do with the data that we collect. And I said, okay, and then it said, here's the stuff we do, and here's what we use it for, and I was like, oh, this is super cool, this is what I've been reading about, it's happening. To pitch real quickly, well, not pitch, but so we're working on a bunch of features that will help companies track consent. So we have an identity management platform, and we're building a lot of features that we announced, I think, last week, that will help report consent as a discrete event and track it and implement logic in your data flows to make sure that the consent is honored. So I'll leave it there, but I think it's an awesome topic.
Yeah, I agree. I do think that consent is one of the things that, when I was talking earlier about some misinformation being spread, I think immediately after people started learning about the GDPR, it was suddenly this idea like you can never ever have data unless someone has consented to you having that data, and that is not the case. In fact, there are 6 distinct legal reasons why you can process data that are clearly laid out in the GDPR, and legitimate interest is actually one that covers a lot of the scope of the data that we process on behalf of our customers, and it causes a lot less headache for our customers because and I think this was getting at the root of your question, but the consent. If you're relying on the consent justification, you're opening yourself up to a lot of really intense obligations and monitoring, and I mean these features that that are being built are a testament to that. So I think that's a question that that's the kind of thing where if you do have outside counsel who's really well versed in this and can help you sort of sort through like exactly what your data is and how it's being used and help you determine which justification you want to rely on. That's a really good place to start once you've mapped your data.
If I can add to that, the exercise I mentioned earlier, data mapping, which is truly not mandated by GDPR, but when you map the data, not only identify where the data is, but identify the classification of it, and then identify what type of consent it would need, and if you have already some level of consent available. Again, it all becomes a project plan for you to identify, here's my data, here's the classifications, here's where the consent is required, and then it'll highlight the gap analysis showing you where additional work for consent is needed. And now I've seen a lot of organizations taking that exercise to make sure that they have the scope around it, then they make the decisions accordingly.
Great. We had another question up here. I think we have time for one more.
So my question is, take in consideration in 2018, companies using different approaches. Some of them, they need a framework, a roadmap, and they need a prescription of knowing what are the best approaches of something they have as a reference. If there's a business need to have an international organization for GDPR. We have IEEE, we have PMI. Can we do something like that for GDPR?
I think that sounds great. I'm into it. I think as people that have to, as representatives of companies that have to be compliant, again, it's on us to figure out what's the solution. We don't all have to reinvent everything, to your point. And so I think that those kinds of standards and those kinds of commonalities will emerge, both from how do we be compliant in practice, but also are there open standards? Are there things that we can do to make it easier for everyone, that we can sort of join together to be compliant together? Because you mentioned earlier that we're all in this together, and I think that's true. And there's no reason not to share work and to work together in the same way. So we don't have an international organization yet. I don't think it exists yet, but if you want to start one, I'm in. I'll meet you afterwards.
But let me add, though, there's a lot of reputable industries and organizations out there that are already taking a step towards making GDPR life easier for organizations, such as the IIA, Institute of Internal Auditors, ISACA, ISO 27000 and the like. Even the OCR and HHS for HIPAA, looking at impacts of GDPR to managing health information. that's going to force them to put together the best practices to make life easier. And when I see a trend like that, eventually somebody is going to own it and call it at some point the International GDPR Guidance Committee or whatever it may be. There's no avoiding it, especially as it propagates into the different areas in the globe. There's no avoiding it, but it's not happening yet.
Great. Well, thank you so much for sharing all of your knowledge with everybody. We really appreciate it. And don't forget these three points. We're going to be sharing a lot after this event and different documentation and FAQs with you guys, but this is a really great place to start. I know I see some people that were taking out their cameras when we flipped it last time. So I'll leave you with this and bring Judy right back on up. Thank you.
Thank you so much, panelists. So next up, as you can probably imagine, a lot of our panelists talked about data treatment, data mapping as one of the key challenges of GDPR. Why it is such a challenging feat is because a lot of us use third-party solution providers, such as cloud hosting platforms, CRMs for our sales, HR management platform for employee data. All of these are third-party vendors that could touch part of our data. So the next panel will really talk about how to work with third-party providers, and we put together a panel based on two companies that are both data controllers and data processors. The panel will focus on how you, as a data controller, can work with data processors. But if you have any other questions on the dual role, please feel free to ask after as well. So we have Doreen Fayette, the head of legal from Mailjet, as well as John Hyman, the CTO and founder of Braze, on stage. The panel will be moderated by a journalist who has passionately followed GDPR development over the last 2 years. Her name is Hillary Adler from Direct Marketing News. Let's welcome them on stage.
Everyone, totally digging this music here.
How's everybody doing?
Sounds like we need a little bit more coffee. Oh, I said it sounds like we might need a little bit more coffee.
How is everybody doing? Who in here, by raise of hands, feels like they have a good grasp on GDPR? Okay. And then who feels ready for the May 25th deadline? You're in the right place, if you didn't raise your hand, which is everybody. All right. Do you guys want to introduce yourself?
Sure. Hi, everybody. Is this even on? Are you listening to me? Hello?
I'm on.
Technical difficulties. Thank you. Mic test, 1, 2, 1, 2.
This mic work? Here, why don't you take mine for a minute?
Hi, my name is Doreen Fayed, and I am the head of legal and the data protection officer at Mailjet. So I've been with Mailjet for about 2 years, and we've been on this GDPR compliance journey. Journey is a nice word, for over a year. I'm based in the Paris office, and at Mailjet we handle large-scale personal data of European citizens, of Australian citizens, of American citizens. We are handling emailing across the globe, and so this is a really important subject for us, and we've been on the path early on when there wasn't much information about the topic, and so we would just like to share our experiences, exactly how we went about it, and the important steps to take so that it's not so scary and it's not so strange come May.
Hey everyone, my name is John Hyman. I'm a co-founder and the Chief Technology Officer at Braze. Telling you just quickly a bit about Braze, what we do. We are formerly AppBoy, so some of you in the audience might have heard about us. Our prior name we rebranded a couple of months ago. And what Braze is we are a customer engagement platform that's used by consumer brands to help deliver really wonderful and brilliant messaging experiences to their consumers through messaging. So what I mean by that is we help customers deliver very personalized, real-time, highly relevant push notifications to their consumers, relevant emails, value-add messages on the web or through their in-app messages in their mobile applications or through text messages, et cetera. And so we work with a number of different brands collecting and processing a large amount of data on citizens really all over the world, the United States, EU, Asia, Africa, et cetera. So I'm excited to kind of talk about our role as a sub-processor working with our customers, typically consumer brands, as well as then other things that we look to for even our sub-processors and our partners.
All right, so let's just dive right in. What exactly is the role of third-party vendors in respect to GDPR? And we'll start with Doreen.
Okay, so why are we talking exactly about third-party providers? So everybody in the data cycle who touches, treats, handles data is responsible to ensure that they also are in compliance. So whether we're talking about the data controller, whether we're talking about that data controller's processor or sub-processor or even sub-processor, everybody in the cycle is involved. And under GDPR, which is really important, which was not the case before, is that even the controller is responsible for its third-party providers. So we all use them. You know, we have like CRM systems, our cloud data centers, our IT services. We have chat messaging services. All our departments use various third-party solutions and apps to provide services for our own clients. So we are also responsible for those third-party providers. That's why it's important. We can't just blindly subscribe to various services online and use their services. You transfer our customer data to those services and not check them and vet them. So that's what it's important to make sure the whole cycle is compliant.
Right, so I kind of look at that as that essentially what GDPR is doing is it's giving consumers in the EU like new rights. They have the right to be informed over what type of data is being collected on them and how it's being stored and how it's being used. They have the right to rectification if they think that some of the data collected on them is inaccurate. They have the right to erasure, or we talked about as the right to be forgotten. And so those obligations are things that companies in the GDPR nomenclature, they're called data controllers, need to fulfill, and they have those obligations they have to work through. And then if a company is using any other product or partner to fulfill any part of their data processing, that's then the data processor, then they have to make sure that their data processors are enabling them to fulfill their obligations as well. So with Braze, since we're actually working with a lot of consumer brands and collecting information on their end consumers, for us, we wanted to be a great trusted partner to them such that we make it very easy for our partners and our customers to be able to fulfill those obligations, whether that is through updating our services, making new APIs for them, talking the way about we do through our documentation. And so it's just ultimately important for any partner to make sure that, as kind of Doreen is saying, that like everyone's all kind of in this together now, and everyone has to make sure that the obligations are fulfilled by the controller.
And so why do we need to worry about your data processors? Why do they need to be compliant?
Well, so kind of the one thing I'll say with that is, at least with Braze, we use a number of different sub-processors ourselves in order to fulfill our business. So I mentioned before that one of the things that we can do is we can send relevant, personalized emails. And we actually use MailJet to deliver a large amount of emails for us, for our European customers. And so we're responsible for the acts and the omissions of our sub-processors because we are providing a service to our customers, ultimately the consumer brand. And so it's important for us to know what MailJet is doing such that we can then fulfill our obligation back to our customer there. So, I mean, really, like when you kind of just look at it, it's that like you have to be taking this as seriously as, if you're a processor, you have to be taking this as seriously as your controller is. Otherwise, they're not going to be able to fulfill their obligations, and it could have really negative consequences for you to the tune of 4% of global turnover, to the tune of $20 million. And there's a lot of actually examples of customers and companies who've already been fined over data privacy related things.
I think if we just, John, put a very concrete example to what you just said. So Mailjet is handling the emailing for Appboy. So let's say tomorrow there's a customer of Appboy, of Braze, who asks them, please, I would like today that you forget me completely. Now that's right to be forgotten, which is different than just unsubscribe me from your emailing. This is really a standard that's a new obligation on the part of Braze today. They need to be able to delete that piece of personal data completely from their system. So today, if that customer asks Braze the right to be forgotten, Braze can specifically request that to Mailjet, and we have changed and revamped our IT process in order to quickly respond to that data subject's request, which is an IT process of hashing. It's anonymization of the data. So today, if there's an email, john@braze.com, tomorrow we will anonymize that. So it will be a hashing process. It will be xxx@appboy.com. We no longer can identify that personal data in the system. And that's what we're talking about, having the data processor also be able to allow the controller to respond directly to their data subject's request.
So one thing I think that kind of just talking on what Hillary's asking as well is about like why it's so important is before this panel, actually, Doreen and I were talking about some of the fines and some of the real serious consequences to not following GDPR. And was telling me a story about a French electronics company. I think it might be a good
Sure. So it was just in the second week of January when the DPA in France, it's the French Data Protection Authority, it's the CNIL, they fined Darty 10,000 euros, 10,000 euros, 100,000 euros. And that Darty, it's like, you know, Home Depot. Basically, they're really big in France, and it's a big company. And basically, that company was using for their customer service, after selling products to their customers, kind of an online form by a third-party provider. So that customer would go onto this third-party provider website and just fill out their customer information. Well, it was a security breach in the fact that it was not being protected, and anybody, any like John or his cousin or Mary could access every customer's personal information on that website. And so CNIL had advised Darty, they gave them just a notification saying, oh, you guys, you have some kind of breach, and they did not vet this third-party provider. They did not go in and say, well, what protection measures have you in place to ensure that there is not the security breach? They didn't do that, and because of that, they got fined. And today, I think the fines under GDPR are going to be up to 4 times increased in amounts. So we're not talking about 10,000 euros or 100,000 euros. It's going to be heftier fines. And I think for US businesses, something that is really important, it's not just about the fines, because maybe the DPA of various countries will not specifically fine you. It's about your customers and the fact that they can put on social media their complaints, and that's gonna skyrocket. You're gonna be put out there saying, oh, well, this company, this brand does not respect my rights. They're not respecting my data protection, and so that can be just a reputational risk. And so you no longer will have these clients coming back to you. You will no longer have, it will just be, you know, a high client turnover. So there's also other consequences. We're not just needing to be mindful about the fines.
Well, I think then kind of like if you look at what you just said around the fact that here is a company that then got fined for kind of not really vetting their provider, their processor. And I think that it becomes really important for data controllers to now start thinking about who their partners are and what their partners are doing. There's kind of this whole world of business models that exist kind of out there of people and brands and companies that sell data to other brands and data services. And you can think that like none of that now under GDPR is going to pass muster. So we even see it kind of in our mobile space right now, where there are a number of mobile platforms and mobile SDKs and mobile companies that what they do is they help with advertising, and they kind of collect data from devices. Maybe they're providing you a service like they'll send you push notifications in exchange for your device data that then they'll go and resell. But now consumers have to give consent for all of the uses that their data is going to have in the ecosystem. And so for you as a company, if you're contracting with a partner that then maybe you're using them to send you push notifications, and then they're taking your data and they're selling it to some other provider and kind of making money on the back end on that, you're now going to be liable for that, just in the kind of example that you see here. So it's really important to vet your partners to know what are they doing with your data, what are they going to do, what data are they collecting, and essentially how they're treating it. So like with Braze, one approach that we've always taken is that customer data that we have is our customers' data. We very clearly define the ways in which we're using it. We have a tremendous amount of documentation around the types of data that we collect, either automatically or that they send to us. We've been pulling in GDPR into our sales process now, actually, such that we're record keeping the types of information that our customers are sending to us, so that way we can just get it now as part of onboarding and part of the sales process. We know what customer A is now sending over to Braze. We can classify it and do our own kind of impact analysis on like what that data is. And then we also make it very clear to them that their data is their data. We're not commingling it and selling it to other customers. We took a very privacy-conscious stand actually from the beginning of our company's inception over 6.5 years ago, that we did not want to like cross-reference data from one customer to another. So you might hear these business models of I'm taking data that I know from customer A, and I know that you also are a customer of customer B, and or maybe we're looking at your purchases in aggregate between the two to figure out who you are. That stuff now doesn't pass muster into GDPR, and Braze has never done that from the get-go. So we as a partner have been very explicit with what we do, and I think that's kind of what you're going to need to see out of partners going forward.
Okay, so John, you just briefly touched on this, but Doreen, how have you vetted your own processors?
So at MailJet, right at the beginning, when we asked the question, let's take a look and audit our third-party providers. At the beginning, this is an obligation under the data protection rules. We had in mind about 20 providers, maybe 25 providers. We ended up doing this audit and coming up with over 80 third-party providers. That was not a number we thought originally. So there's more than you would expect when you first start. So it's really important to identify and make a list of all the providers you're using, whether it's paid for services or non-paid subscriptions. Anytime that you send customer data to a third party, this needs to be included in your list. So we interviewed different members in all departments, because we're not just talking about the legal department or just the marketing department. It's really every actor in our company and every application that they use to provide the services. So it's the IT department, what tools are they using? The salespeople, what tools are they using? And it's really making this list specifically. And once we have identified exactly what third-party providers we are using, we need to then start doing a risk analysis. So we need to go ahead and find out what data are we sending to them. Is it personal data? Is it sensitive personal data? And then we need to make sure we understand that mapping of the data and then vet that specific third-party provider. So how do we vet them? We go ahead and look at their website. We check their privacy policy. We check the contract that we have with them. We check all the documentation that we have with this third-party provider, and then as we went across and doing this vetting process, we sent them third-party provider questionnaires where we really delved into their their processes. And this is where you check their TOMs. It's their technical and organizational measures that they have in place. An obligation of the GDPR is your third-party provider will ensure that those measures are adequate. So you need to check those measures. So with this third-party questionnaire, now some of our third-party providers were not really happy with these questionnaires because they were hefty, but you need to ask the tough questions. You need to keep bombarding them, be aggressive, because guess what? At the end of the day, if they're vague with their answers, if you're not satisfied with the responses that you're getting, you need to make that decision internally. Do we keep them? Or do we switch? Should I stay or should I go? That's really the question that you need to answer after making this analysis. So at Mailjet, this process was one of the biggest challenges of our GDPR compliance. Because we had over 80 providers, and this process took us well over 5 months. And it's a continuous process, not just because we asked them on day one and we got the answers. We put into our contracts with them the right to audit and the right to control. So in 6 months, I will be asking them again these same questions. I will be verifying that they have the same TOMs in place. And this needs to be rinsed and repeated because it's a continuous data protection process. It's a continuous analysis that needs to be done in your organization.
Right. I mean, I just couldn't agree more with everything that you're saying. I mean, I think that like kind of the big kind of takeaway for me is that GDPR is essentially a new way to operate. And it's a way of thinking around data privacy and data protection in a way that hopefully many of you in your IT departments have also been thinking about security. So for us at Braze, I've just real quick on security, you heard Susan Wiseman talk about this earlier. There are a number of audit certifications that one can get in order to have third-party attestation on your security controls. You can do ISO 27001, you can do SOC 2. These are kind of the gold standards and also things that Braze works on. But with GDPR, there's not a great way to know if someone is going to be compliant. But when you think about like the principles of these like ISO and SOC 2 kind of security things, one thing that goes in there is the focus on how secure are your sub-processors. And then once you kind of starting getting these compliances like your SOC 2 compliant, you really only want to work with these SOC 2 compliant providers because you have to make sure they're fulfilling the same security obligations you are. With GDPR, it's now kind of the same thing with data protection and data privacy. And so for us, we did a very similar thing to what you just heard described, essentially looking at all of the partners that we use, both as a sub-processor for us, meaning like when we, Braze, are delivering a service to our customers, who's helping us do that? And like for example, Mailjet helping us deliver emails. But then on the other side of it as well, as a business ourselves, what data are we sharing just to run our business, our marketing department, our sales department, our legal department, kind of the other aspects that was kind of touched upon. Doing a risk analysis and then following up, essentially just building that program into your vendor evaluation that should generally exist from a security point of view. Now you're looking at it of what are they doing with respect to data protection, what's their minimization policy, how are they fulfilling my needs to fulfill the obligations under GDPR, again, the right to be informed, right to erasure, right to rectification, all of those things. And you just really have to like aggressively kind of look at that. But in order to do that though, again, there's not like a way, there's not a certificate you can kind of point to. I look toward vendors at the level of preparedness that they have, the level of diligence that we're seeing them kind of bring to the table with respect to GDPR. So just, I know what like Braze has done, and like we started more than a year ago. We hired Field Fisher, a prominent EU law firm that works on GDPR-related and privacy-related issues to help kind of perform this large gap analysis for us at our business with kind of the things that we need to put in place for GDPR compliance. And then we've been trying to be extremely transparent and be a very good trustful partner to our customers. And what that has meant is that we've produced things like a GDPR roadmap, where we now are giving that out to customers. These are the things that we're doing. This is where we've been, where we are now, and where we're going. Publicly make that available to our customers. Update our website with all the things that we're doing on GDPR. On the product side of the house, for using our product and the services we sell, providing FAQs for our consumers and our customers on how they should use our services to fulfill their obligations under GDPR. We're writing thought leadership pieces on our blog. We're putting in our digital magazine what GDPR means for you. We're kind of co-sponsoring a conference here. And it all kind of just shows a level of thought leadership, diligence, and like taking the GDPR at the gravity that it is into effect. And so I think if we're looking with a vendor and they can kind of show us these types of things, that's really comforting to me. If we work with a vendor that, example, I'm asking them right now, give me some kind of data processing amendment that mentions GDPR, and they don't have it yet, it's kind of a yellow flag there. Or I talk to them about GDPR, and they're like, yeah, you're fine, and I ask for follow-up documentation, and then they're just like, oh, well, here's our privacy policy. It's like, it's not really good. So we really need to start evaluating them very seriously with the level of preparation they're doing for this massive change of operating.
And so just to quickly wrap it up before we turn it over to the audience, what advice do each of you have for companies looking to vet their processors?
I think for us, it's also about taking a pragmatic approach. So the advice could be, this is also just sound business practice. The fact that you have kind of a purchasing center or control center every time there's someone in your company that wants to use a third-party application. Now there's a certain centralized process that we're vetting these third-party providers overall, not just for data protection, but overall for good, sound business practices. So a tidbit in MailJet, we were using various solutions for outside services where the principle of this data minimization came into play, where we said, well, is it really necessary for us to be using this third-party application? The more third parties we use, maybe the higher the risk is for some kind of data breach if we're sending our customers data left and right. So also on a company standpoint, we decided to internalize a lot of the processes. For example, type forms we were potentially wanting to use. We internalized this process, and today when we have a forms requesting for our customers, we use that ourselves, and it's internalized, and we are safe and sound with that data staying within our organization. So it's also about taking a global view of all your third-party providers and making that decision. So it's also a sound business practice for you.
Yeah, I think there are really kind of two parts that I would just recommend with respect to vetting vendors, really aside from the kind of preparation bit that I was just talking about a moment ago. One is just making sure that you understand all the data that you're needing to send to a partner. And this is a part of GDPR's record-keeping obligations, where everyone needs to just kind of get more buttoned up with respect to knowing the data transfers that are happening, the types of data that you're sending, and that fits in with that minimization piece where you really, under GDPR, should only be collecting, processing, storing data, the minimal set that you need for the purpose you're doing it, and only storing it for the duration that you need and not longer. So once you kind of know that, you can then understand the risks that are inherent to working with a provider versus another one. And then I think really kind of just the second part of that is then just asking questions. Say to a vendor, how do I fulfill this obligation using your service? Let's just kind of play this out. Let's say that someone comes to me and says, hey, John, I want you to erase my data because I have every right to do that. How are you going to enable me to fulfill that obligation? What does that process look like? Essentially, what you're just trying to tease out is, are they a good partner? Are they going to be a good provider? Are they going to work with you with GDPR? Because again, we're kind of all in this together. Or are they going to be like, well, that's kind of your responsibility and we don't have to think about that. So just get those questions out in the open from the get-go. What are you doing to allow me to fulfill this obligation? What are you doing with respect to minimization? And then that just factors back into that impact analysis you're doing by knowing what data you're sending out there.
All right, I think we have about a couple minutes for 2 to 3 questions. Yeah, sure, in the back. You, yeah.
Thanks very much. From a risk allocation perspective, do you seek to negotiate indemnification from your third-party providers?
That's a very nice point. There's always contractual elements that you can add specifically with your third-party providers. It's part of also the negotiation of your contract. So it's important to add specific clauses with your contract. So specific clauses could be a shared responsibility, limitation of liability, indemnification, but also what's really important to put into contracts could also be specific requirements that they follow the TOMs that were expressed. So you put the TOMs in an annex that they provided by their questionnaire form, and these TOMs become a contractual element of your relationship. Indemnification is important as well because if there's a breach, it's also important to identify the source. So if you can come up with some language in your contracts that can do this kind of shared responsibility or responsibility on one party or the other for where the breach stems from, it's also a very good idea. So it's part of the negotiations of the contracts. And then if there's any transfers being in terms of customer data, maybe transfers from the EU to the US, it's also a good idea to put in some EU model clauses with your contracts with these third-party providers to ensure the right standards of protection on data.
Does that answer your question? Or John, do you want to weigh in?
Oh, well, first I'll just say I'm not a lawyer. So we do actually have Braze's SVP of Legal and General Counsel, Susan Wiseman, here. She was on a panel earlier. I'll probably be able to find her after this break. But I can tell you that at least as a provider of services, Braze's stance is that we're responsible for the acts and the omissions of our sub-processors. So if our sub-processor has an issue, and whether that was a security issue or a data privacy issue or a uptime, downtime, related issue, that all ultimately falls over to us. The contracts that then we have in place between us and our sub-processors likely then will just vary through negotiation. But for the actual indemnification details, Susan actually might be a really great resource to kind of talk you through that. Susan, if you're here and raise your hand, she's back there. And would I'm sure be able. I'm sure she's loving that I'm directing this question to her for the break when she wants to get something to drink. But you could go chat with her.
All right, we can take another question. Sure.
So we have exception to the rules. I'm sorry. We have exceptions to the rule. Let's say I'm running my company. We have to be in compliant, relationship with business partners and vendors. But during the process, there's some type of legal intervention or investigation, and that data privacy is not going to be there. We have the FBI, CIA, or something like that. How do we handle that?
So if I'm just kind of understanding your question kind of correctly, let me just preface this with the fact that when we talk about data protection, data privacy, there are a couple of different ways in which a business then has the legal and kind of jurisdiction under GDPR to collect and process that data. One of which is consent that we've talked about a lot, but there's another part of it of legal aspect. If there's something in the public interest that overrides an individual's interest in storing, processing, and using that data, then a company has every right to do so. I think you kind of look at this from like a legal point of view. I was actually just joking beforehand saying I really wish the US government was subject to GDPR so I could see what they're collecting off my phone. But unfortunately I probably can't, because what they're going to do is they would, if I ever got a response from the US government, I'm sure they would just say, well, John, we're trying to fight the terrorists and that supersedes your interest and we're just doing this for your own safety. And so there is kind of that legal aspect to GDPR where if you need to keep things around from a legal perspective, we're still going to do that. So we heard an example earlier about how MailJet might anonymize the recipient of an email. It's no longer john@braze.com that they sent an email to. It's xxx@braze.com. We've got some businesses, namely financial companies, medical companies, for whom they need to keep detailed records on who they send emails to. And for their own financial regulations or business regulations, or even they're trying to do it under just being a good provider in their country. So we can't actually delete some of that stuff. If you look at like fulfilling the right to erasure. Like we couldn't say, well, we did send you an email yesterday, but now we're going to erase from our system that we sent it to you, because we might need it for compliance, we might need it for discovery and a legal phase and a legal process, et cetera. There might be some reason to kind of like keep it there from a compliance and regulatory standpoint. And the big thing with GDPR is that it's going to look toward the like legitimate interest of kind of the situation at hand in order to kind of make the determination on what to do there. So I'm not sure if that fully kind of even gets at your question, but if not, we can kind of chat perhaps after the break.
I think just to rebound on John's last point, which is really important, the fact that there could be other legal basis for the fact that you're either keeping that data or doing other purposes behind that data. It's really important on a GDPR standpoint to document your internal decisions in your company. So for example, if someone does ask the right to be forgotten, you do have a legal obligation to keep your invoices for a certain period of time for an accounting standpoint. So you're not going to delete all the invoices because that's just going to corrupt your other practices. You will document that you identified the issue and your decision behind that issue. So I've been in a lot of conversations with Data Protection Authority in France, the CNIL. So I've had conversations with them on this point, saying, what happens when, we didn't delete the data because we have other obligations. The CNIL, their position is that basically there are some new obligations that companies are supposed to respect today under GDPR. They are new obligations. So we don't have 100%, we don't have that hindsight to know exactly how it will be interpreted. So there are some data protection authorities' stance that they will be there to accompany you in your compliance. So it's not just, they're not just there with their controller hat on. They also have a hat and a role to be there to guide you. So if they see that you have good faith in documenting your processes, you have good faith in showing that you are on this compliance journey, then they may not just immediately fine you from the beginning. They will be there to help you and answer your questions so that you will be in compliance. So there's also that other aspect. So when at the beginning I said, we're also here not to show you not to be so fearful from the beginning about this GDPR, there's also this aspect that there are new obligations. The data protection authorities know that. And if they see that you are in some kind of compliance positioning, then they will be there for accompaniment as well.
And then we have time for one more question. Sure.
Hi. What advice would you give to a third-party provider who's going to be receiving these questionnaires all the time to signal to their customers and regulators and instill confidence that they are compliant with GDPR?
I mean, essentially to prep. It's well known what those rights are. It's kind of well known that what the date of which GDPR is coming. And so just kind of get it ready and act as if it's kind of already here. In fact, I kind of like we've joked around a bit internally that GDPR, even though it doesn't take effect until May 25th of this year, is actually really already in effect for us because it comes up in sales conversations. It's coming up. All of our customers want to know what we're doing with GDPR. All our prospects we're talking to, whether they're in the EU or not, are trying to understand what we're doing. So I guess kind of the advice is, one of the simplest things you could just do is start with the rights and then just try to write a response to that of how am I fulfilling the obligation under that right for the service that we provide. That's very separate from, I think there's a lot of other things you need to do to evaluate like your data protection, your lawfulness, your security, like how you handle data breaches, like all these different things, like your minimization principles, how you do data privacy by design and by default, like how you do all of that. You kind of can put together that plan, but just the first step, I'd say, how do we fulfill these rights? And just get something out there that you can then be customer facing of like, here's how we help enable you to fulfill your obligations. And then separately, when you figure out all that other stuff or you put the plan to making the plan, just share that. and just be very open with the fact that GDPR is coming. We take it very seriously. Here's the things that we're doing, and just kind of show them your dedication to what you're doing. But it also has to be genuine. I mean, you can't just put this together. Antonis, who spoke earlier on the panel, he said, if you start today, you're not going to finish in time, but you should start tomorrow if you haven't started today. And so that's kind of just basically it. It would just be to kind of start prepping.
I'd signal you to go to the MailJet GDPR resources website. So where we have, in all transparency, put out some information on our own compliance roadmap, and we have a third-party provider checklist where we list the top 15 questions that you should be posing to your third-party provider. So take a look at those questions and answer them for yourselves. And an example I would give you is on different standards today, like the ISO certification. There's the ISO 27701 certification. At MailJet, we have that certification. Before we did receive it in October of last year, we were getting from prospects these questionnaires that were more or less the same questions over and over again from really Fortune 500 companies and their detailed questionnaires. The first time we saw that questionnaire, it was really difficult and long-winded for us to respond to it, but we did it. We took the efforts behind it to go ahead and respond. And afterwards, it was kind of the same questionnaire, the same questions and responses. And then it basically took that ISO certification, replicated it with the questionnaire. Same thing with GDPR. It's basically the GDPR obligations for controllers. They take those questions, and once you answer it the first time, you will be more prepared for the second time. And it's giving that principle of transparency to your customers and to your other providers, saying, listen, we took the efforts, we put this internally in our own processes, and this is how we address it. Being transparent is key.
All right, so that brings us down to the bottom. Thank you for your questions, and thank you, Doreen and John, for your insightful answers.
Thanks, everyone.
Thank you.
Wow, what a wealth of GDPR knowledge. I hope all of you have enjoyed our panels this morning, and I know some of you still have a lot of burning questions. Following the break, we will deep dive into a lot of the marketing and IT specific technical implementation type of questions to help you understand the exact steps that you need to take to become compliant. Just a couple of housekeeping items. We'll take a break for 10 minutes where you'll find refreshments, snacks outside. And after 10 minutes, the marketing panel will resume in this room, and the IT panel will continue in the hub, which is the room just outside. So hold your questions, get refilled, and we'll see you in 10 minutes.